Hi, it's Jan Boback from Anderson and Boback. Talking today about can I move with my child? Removal used to be called removal, and in the state of Illinois, it was pretty straightforward. You couldn't leave the state of Illinois without the other parent's consent or court approval. The law changed in January of 2016. And it was quite a significant change. For one thing, they call it relocation now. If you wanted to move more than 25 miles away from where your child lives, you had to get permission from the other side, consent from the other parent, or you had to file a motion with the court and get permission through court order, through a hearing if necessary. Now, if you live outside of those highly populated counties, outside of Cook and Dupage and Will and McHenry, it was 50 miles. There was a 50-mile radius, so we would consider that maybe downstate. Then it provoked the requirement that you had to get permission from the court or consent from the other party. So after the change in the law from removal out of state to relocation, there is quite a significant change, because prior, when it was removal, prior to January 2016, you could live in northern Illinois and move to southern Illinois, which is it's quite a distance, many hours of a drive. And that was okay. That was something that you could do. Of course, parenting time would have to be modified, but you certainly had the right to do that. Well, when the law changed in January 2016, now called relocation, it was changed to state that you had to, if you move this 25-mile radius or 50-mile radius in a smaller populated area. So it wasn't necessarily out of state anymore. Now, please keep in mind that if you do want to move out of state, even if it's just over a border, a few miles, like northern Illinois to Wisconsin, you had to get permission. You had to get consent or permission. So out of state still invokes the requirement, but now there's a mile radius as opposed to just out of state. First of all, you have to be either the primary parenting parent, which means you have more than 50% of the time, or you had to at least have 50-50 time. You had to be one of the primary parents. So that's the first thing. Now, if you want to move with your child and you don't have 50-50 time and you're not the primary parent, the first thing is to modify your time. You would need to file a motion or get permission from the other side and do a modified order that would make you the primary parent, or at least a parent with 50-50 time. That would allow you the ability to file and request the court that you want to move. So the first thing you do is you give the other side notice. I know sometimes 60 days is not practicable, and there is a caveat for that. If it's not practicable, if something comes up, if it's in a situation where you can't give 60 days notice, that's provided for in the statute. But under the statute, 60 days notice, you send the notice to the other side saying a couple things: where you're going, when you're going, and is this a temporary move? Is it a permanent move? Is it a specific amount of time? Those types of things need to be in the notice. Now you take the notice and you file it with the circuit court. So there's a notice sent to the other parent, and there's a notice sent, the same notice is filed with the circuit court. If the other parent agrees, they'll sign it. And then when you get that signature back, you'll file that with the circuit court. And nothing else needs to be done as far as removal. Then you can leave the state or the distance, whatever you have requested, as long as it's by agreement in that fashion. I'm assuming that a lot of parties, if they do this by agreement, would come up with an alternate parenting plan because of the distance moved. And that would also likely be approved by the court, as long as it's in the best interest of the child. That's, of course, the primary interest of the court is what's in the best interest of the child, and they're going to want to make sure that that's the case. Now, if the other parent doesn't agree, then they won't sign it, of course, and then you have to file a motion with the court. You have to file a motion and have the court decide through hearing, if necessary, if you can relocate to your required place. The court's going to take some things into consideration when you're asking to relocate from the state of Illinois with your child. The court's going to be interested in why is the parent moving? Why are you moving to this new location? You're going to need to provide good reasons. The court's going to want to consider what the purpose is or what the reasons are behind the other parent objecting. The court's also going to want to know what's available to the child here as far as education and activities, and what's available to the child where you're going to be moving as far as education and activities. Is there family support here and there? These factors are very important to the court because they're only going to make a decision if it's in the best interest of the child. Another very significant factor in can I relocate with my child or remove my child is what's the parent's time with the child now, and have they been actively exercising that? If they have 3 days a week or 4 days a week, or if they have a lot of time with the child and they've exercised it and they're participating in the child's life very, very regularly, then that's a more difficult situation in convincing the court to remove, particularly if you're moving quite a distance, where that same involvement would be difficult or maybe impossible. Now, if you have a parent who's an every other weekend parent, sometimes they exercise the visitation, sometimes they don't. I mean, that's another situation. The court's going to look at that. How is this move going to affect the other parent? And if they do consider that it may be in the best interest of the child to move, they're going to say, well, then what kind of parenting time can we implement or put in place that would benefit everybody involved, particularly the child? So is it possible to recreate some type of a schedule to keep the parents connected? So those are all very important things for the court. So the answer to the question is yes, you can move out of the state of Illinois or 25 miles or 50 miles from your home if you're the primary parent, or at least have 50% of the time. But you need permission, you need consent from the other parent, and if not, you need to ask the courts. Now, there are situations where domestic violence is involved, and the reason that you're moving, relocating, and taking your child has to do with potential domestic violence or past domestic violence. The courts take that into consideration, and you still have to provide a notice, but you may not have to put your address of where you're going if domestic violence is an issue. If there's anything we could help you with at Anderson and Boback, we're continuing to work. Most of it's virtually during this time, and we're happy to talk with you. Please let us know, and be safe, be well, and hope to see you soon.